Hello and welcome back to KG Law. I'm Kelly, the owner and founder of KG Law here in Sterling Heights, Michigan. Just a little bit that has come up recently. We've had my family has been dealing with an emergency since just before Christmas, and it's brought to light a lot of confusion that a lot of people have. And I just wanted to take a few minutes and share a bit of information that maybe other people will find helpful, right? So, what has come up is um, how powers of attorney work, and also when you may need a conservatorship versus a guardianship, or do you need both? Do you need either, right? So, again, understanding that I come from this being licensed in the state of Michigan. Your state may have a little bit different stance on this, so you're going to want to talk to somebody licensed in your state. Generally speaking, though, this goes for every state that I'm aware of. So, a person can elect, if they are over 18, so they're an adult, and they are of sound mind, they can do what is called a durable power of attorney. That can address both your financials and your health care. They are separate documents, generally speaking. If you come here, they're going to be separate documents. You can elect different people to handle both things, right? So you may have, let's say you as an adult have two adult children, and one is a doctor and one is an accountant. First of all, holy cow, don't want their student debts, but great resources, right? So it may make sense to make your child or your adult child who is an accountant in charge of your finances, right? And it may make sense then to make your adult child who is a doctor in charge of your medical care. That stands into place only with the power of attorney, only when you are not able to make those decisions for you. Now, we all want to believe we're going to live forever, and I 100% get that. We also don't want to believe that we want to think that we're invincible, and the reality is sometimes we're not, right? So, and we saw that a lot during the pandemic, and I think that brought to light for a lot of people the need to have these things put in place. So let's say financials are easy, right? I always tell my people, let's say you're on a cruise to the Bahamas and there's a storm here. We're in Michigan, snow happens, rain happens, and there's a storm, and a tree falls and takes out your back fence, right? Your financial power of attorney can actually call the insurance company and get the ball rolling while you're out in the Bahamas on a cruise ship, right? It doesn't necessarily mean that you are sick and dying, okay? These are good things, especially as my mom, I always say my mom, my power mom gets used as an example for a lot of things. So as my mom is getting elderly, it would be, in before, God forbid, we start dealing with some dementia or Alzheimer's, we want to make sure that her wishes are followed, right, for her health care. We want to make sure that if she needs to apply for things like Medicaid, that we have the ability to do that, right? So right now, while she's of sound mind, it would be really easy for us to draft those documents so that we know going forward what are her express wishes, right? We don't get to override her express wishes as a power of attorney. There's a fiduciary duty. And so we're going to follow exactly what's spelled out. If she says she doesn't want life-saving measures, we don't do life-saving measures. If she says she wants anything and everything thrown at her in a crisis situation, then that's what we do, right? So when I do a power of attorney for somebody for their health care, it also addresses some of the mental health stuff. So she says, I don't have the right as her power of attorney to put her in a mental institution and do that. Absent doing a 5150 petition with the court, I can't just throw her in therapy. I can't just do that. Okay. So, under a power of attorney, we're following what that person's wishes are if we're the person who's accepted the duty to be their power of attorney. All of that's spelled out. Okay. However, let's say something happens and they don't have a power of attorney. In my case, it's with my ex-husband. He didn't have a power of attorney, and now he's in a position where he can't make decisions on his own. Great, guess what? Decisions still have to be made, and his kids are adults, because they're my kids too, right? So our kids are adults. They're his next of kin. His parents are gone. His only nephew that he talks to on occasion lives in New York, and is like, I'm not that person, right? His kids are like, Mom, we need help. Well, he doesn't have a power of attorney. So now what happens, right? So now we're going to have to, we filed with the county that he had a residency in. Give me 1 second. For both a guardianship and a conservatorship. In this case, in my case here, in this example, they'll work hand in hand, right? So a conservatorship, in this case, gets to handle his Social Security benefits that are coming in and buy him, if he needs new shirts, if he needs, new medicines, if he needs shampoo. I'm the person who was going to handle his medical or his financial affairs, right, under a conservatorship. Understanding that the court is going to hold me to a duty, I have to account for what I'm spending on him. I can't go running up a bunch of bills. I can't go buying houses under his name and just because, right? I can't do that. I still have to take care of him in a responsible way. Okay. I also will have to do an annual accounting to the courts. I'm going to have there are responsibilities under that, right? But now I act as if I don't know his wishes. So I act in what I think are his best interests under a conservatorship. Talking about the finances. I can apply for Medicaid. I can apply for all of those things, right, that he needs. I can pay his bills. I can do whatever, okay? Under a guardianship of a, this is, and again, we're talking about a guardianship of an adult. An incapacitated adult. For whatever reason, right? Under a guardianship, I get to make those medical decisions. I get to make those decisions about where he's living. I get to make those decisions. So maybe I do put in a DNR because I think at this point that's what he would have wanted, right? And quality of life. I get to decide in the case of my ex-husband what nursing home facility he's in. I get to decide all of those things, right? It doesn't matter because we don't know what his wishes were. There's no legal document. So I have to go on conversations that I've had over the years in knowing this person to make those decisions. And that's appointed by the court. So absent the court removing me from that position, his kids could decide tomorrow that we don't want mom to make those decisions anymore. Mom's, whatever, for whatever reason, they've decided that now they want it. They would have to have a petition into the court to remove me versus a power of attorney where if he suddenly could start making those decisions, he would have to have the courts remove me and prove he could make those decisions on his own and to remove me as a guardian. So that's kind of what we're talking about. So if a person's already incapacitated for whatever reason, right, I can't get a power of attorney. You can't. Okay, it has to be done when the person is fully aware of everything that's going on and understand documents that have to be signed. If you don't have a power of attorney, then that's when we look to the courts for a guardianship or a conservatorship. We at KG Law would absolutely be able to help you navigate that and figure out what you need and when is appropriate for what. So I hope that little bit of information helps. I know several of my friends have been asking and trying to understand the system. So if you have any other questions, feel free to reach out to us here. Have a good day.